Evening to you, ladies and gentlemen. I am happy to welcome you to the 18th webinar of Series 6 on Basics of Law titled Domestic Violence Act. This is the 53rd BSR webinar for the years 2025-2026. This webinar series is organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. I would like to take this opportunity to thank the Chairman of the Webinars and Legal Symposiums Committee and the President of BSR, Mr. Rajiv Amarasuriya, the co-chairman, Mr. Chature Galhena, Secretary of BSR, and Mr. Pasandu Silva, Treasurer of BSR, the conveners, co-conveners, and the members of the Webinars and Legal Symposiums Committee. I would also like to extend my heartfelt gratitude to the Executive Committee of the BSR for all the support and guidance. For today's webinar of Domestic Violence Act, we have with us an esteemed panelist, Mr. Lakshan Dias. Mr. Dias is an attorney at law of the Supreme Court of Sri Lanka, having taken oaths in the year 1999. He is a prominent counsel in the areas of family law, including custody, divorce, maintenance, and domestic violence cases, fundamental rights, human rights, writ applications, civil law, refugee law, criminal law, real estate law, law related to defamation, and commercial law. Mr. Dias is also a member of the Executive Committee of the Bar Association of Sri Lanka and the chairperson of the Human Rights Committee of BSL. I warmly welcome Mr. Lakshan Dias, attorney at law, for today's session. To moderate today's session, we have with us Ms. Ravindra Sumatipala. Ms. Sumatipala is an attorney at law practicing as a civil counsel and was a visiting lecturer at the University of Peradeniya, IBM campus, CFPS Law School, and Villa College, Maldives. She is also the holder of a postgraduate diploma in international relations and a Bachelor of Science degree in molecular biology. I also warmly welcome Ms. Ravindra Sumatipala, attorney at law, for today's session. And without taking much time, I invite her to commence today's proceedings. Over to you, madam.
Thank you, Isuri. Good evening, everyone. So today we are focusing on a very important aspect of our legislation, which is actually a very vital subject, the Domestic Violence Act, or rather the Prevention of Domestic Violence Act of Sri Lanka, which is a cornerstone of the legal framework of Sri Lanka, which especially provides individuals from abuse and upholding the rule of law within a most personal sphere, which is the domicile. So we have Mr. Lakshan Dias with us, who is a very apt counsel and a very senior counsel who has been working very closely in this area. And especially I have also seen, I have worked also with him when it comes to Domestic Violence Act. And we are here to discuss about the scope of this act, its challenges, and the continuing effort to ensure justice and protection for everyone. So one of the key features of this act, or rather this legislation, is that it recognizes abuse not in a limited scope, but rather more than a physical harm. It includes any conduct that causes mental or emotional distress. And at the same time, it gives very swift legal protection to individuals. What I see mostly is now this enactment came into our law, came into being in 2005, so which is a very young legislation in comparison. So, sir, shall we start this discussion with the intention of it? And why did it take so long for Sri Lanka to enact such legislation and make it part of our legal framework?
Yeah, thank you, Ravindra. I think the last law that enacted by the Chandrika Kumartunga government in 2005 is this law, because soon after this law was enacted in 2005, October 3rd, soon after that, there was the presidential election. That's a new president was elected. Now, I think it's significant because one way it was a woman president that we had in the country when we enacted these laws, and we had women prime ministers as well. But for some reason, this law took a long time to enacted by the parliament. Maybe because of the backwardness or the patriarchy or the the male domination within the society, at least within the legislature. Because we know as the numbers are very low, even up to today, the numbers comparatively, this parliament has more number of women, but in the past it was very minimum number when you compare with the rest of the Asian countries. So that can be another reason. And also the whole attitude, if you heard the Hansard, I followed the Hansard also in 2005 closely, and the discussion took place at the parliament. Some MPs introduced this law as a divorce law, and they flatly refused, said, no, we don't want this act because it will create unwanted family disputes. And they used a particular word that said that Ambusamiyange Taraha Marha Bathali Dinaturu Pamani. I mean, they said until the pot of rice is boiled, only the family disputes are there. So the Sri Lankan culture is not as such. So therefore, we don't need to go deeply into this. Let the family solve this matter. So they were not very keen. But for some reason, Minister J.L. Peries brought this law and somehow been able to pass in the parliament. So it was done. Actually, if I compare the Sri Lankan Act with the Indian Act is 2 weeks older than us. We are 2 weeks younger to Indian Act. But in my opinion, being a culturally backward country at that time, I mean, India is more open when it comes today. They were more progressive, in my opinion, looking into the issues of domestic violence. But one other thing is that the Sri Lankan Act is covered there's no preamble like Indian Act. So Indian Act more or less talks about the protection of women. But in this act, not only talking about the protection of the household, the domestic. So that is the most important part for me. In our act, we are maybe a bit broader than India in other way, where we talked about the household, mother, father, children, house, husband, wife, so on. So I think we better carry forward this legacy of the domestic instead of protection of women, which is highly covered by the act. But it is not only covered by women, but it's also covered children. It's also covered men. So in that way, I feel, yeah, go ahead.
Yes. Let me pose the next very important question. The moment you call it the Domestic Violence Act, or rather the Prevention of Domestic Violence Act, the common idea, and it is commonly identifies as something that is to prevent violence against women, whereas it doesn't. It's not only for women; it's for men, women, and children. So, who are exactly the parties who are covered by this act?
Yeah, now that's why we are different, a bit different from the intentions of the act from India. So, in my opinion, and I have seen that any aggrieved party, now Indian Act also talks about the aggrieved party, but in our case, in the Sri Lankan Domestic Act, any aggrieved party can go to courts. When you say aggrieved party, they have not limit the aggrieved party. The aggrieved party can be an old father or old or aged mother, a child, the guardian of the child, a wife, and a husband. So all these parties are entitled to go to courts to secure interim order or protection order or interim protection order, or any other relief by the act. So it's widely covered area, and also and not only the guardian, or we can say an aggrieved child, or with whom the child reside, or authorized person by NCPA. So that's also a fact. Now, not only the parents can go on behalf of children, but a guardian whom that child is living, or the authorized person, authorized body by the National Child Protection Authority. So it's a bit wide when it comes to the protection of children, and then anybody of identified, any aggrieved party can go against the relevant party. Now, we in our act, we are not talking about husband or wife. It's very particular. It's an aggrieved party, not aggrieved party, aggrieved person against the relevant party or relevant person. That is how it is described. So in the latter part of the act, they describe and I think in the section 20 the section 23 the interpretation, it talks about who are the relevant person. So they use not the husband or wife, the word, they use spouse. In Sinhala, they call kalatraya. In English, is spouse. And the spouse before divorce or before the separation. And cohabitation or cohabiting partner. And the word in Sinhala, they use sahavasedana sahakaru, cohabiting partner. They don't name the party as spouse or not. It's a partner, cohabiting partner. So it's broader in my opinion. And then they said, then they describe further down in the section 23 in B, they talk about its father, mother, grandfather against that's relevant party, against father, mother, grandfather, grandmother, uncle, and aunt, and son, daughter, grandson, granddaughter, stepson, stepdaughter, brother, sister, half brother, half sister, stepbrother, stepsister, and uncles and aunts, and cousins. They are also going against cousins, and also the brothers and sisters of the parents. So it's very wider. The domestic violence can come from any of those named as a relevant party, as in the section 23. So it's very wide. I think I will describe the lacuna in that one. There are certain areas I think missing, but for the moment, these are the parties. So it can be it's a aged person, mother and or male or female, husband and wife, and children. They're all covered, but not the one thing missing is not the domestic servants or domestic helpers. Domestic helpers are not covered under this one, and not the animals. But other than that, generally it covers.
Right. And at the same time, like now when it comes to the people who are in the domicile, so as you said, like everybody is protected in the family, and that is the case. Now, as I said earlier, now this is a legislation where it gives strict protection, strict remedies. So how do we take this forward, and to whom do we have to make the complaint? Because people always feel that we need to go to police and lodge a complaint in this kind of a situation first, rather than moving to the courts. Is it necessary to lodge a complaint to the police, or can we just make a complaint like this and move forward with the courts?
Act does not say that we must complain to the police. It is not a must thing. It is not a prerequisite. It is not a thing that we must do. But it's good. It's not harm. It's not harm that if you can go to police, that's harm. Now that's fine. But since this is a webinar mainly for lawyers, I prefer lawyers handle. In always, whenever somebody asks me whom should handle this case, I prefer lawyers, because lawyers coming from a legal training where the police does not that much. So when you come to the operation of the Domestic Violence Act, I prefer a trained party files the case. So the Act provides, or Act allowed police to file case. That's fine. If you lodge a complaint especially to the Women and Children section of the police, they will take you to courts. Of course, then the benefit you get is you don't need to pay anybody because the police handles your case. Any crime, the police handles case. But of course, if you retain a lawyer, you have to pay the lawyer. But if you don't have money, still the Legal Aid Commission is there. Legal Aid Commission take a major part, most of their cases are domestic violence cases. So our Legal Aid Commission takes the domestic violence. So it's not a matter of if only rich people can go to courts. Even the poorest in the society can go to courts, can file domestic violence cases in the magistrates courts through legal aid or through your lawyer that whom you retain. So the jurisdiction in the domestic violence cases are the magistrate courts. So when it comes to the private plaint or the plaint by a lawyer, it has to, other than the police, the general police plaint, you have to have an independent affidavit that affirm your part of the story. Now, when the police file an action in the magistrate court, they don't need to get an affidavit from the mother or sister or any other known party to affirm what you are saying. But when you file a case by a lawyer, don't forget that you have to annex an additional affidavit to say exactly the aggrieved person says. To say that I know every fact that the aggrieved person says is true, and therefore I give this affidavit in support of the aggrieved person. So that element, don't forget, because if you don't submit in an independent affidavit, means you made a fatal mistake, because the other party can take the objection that the aggrieved person has not filed affirming affidavit in addition to the aggrieved person's affidavit. And in the section 2 of the act says you must file an identical affidavit which is described in schedule 2. Sakalyan means Sinhala, they say Sakalyama samana veyuti. But there are a lot of judgments to say no need to be exactly identical, but you take the gist of it, and you can you can take it as a sample. In the schedule 2, you have the sample of your affidavit, and also please remember, when you file your affidavit, you have to pray whatever the relief you are seeking in the affidavit, which is not very familiar for us. Now, when in general civil form, when you go for prayers, you are only putting the prayers in the petition. You are not putting prayers in the affidavit. But in this case, this kind of case, you can mention all the relief you are seeking in the affidavit itself. So that's no harm. Other party cannot take objection on that. So if you seeking as per the section 4 and 5 interim protection order, you can ask I pray for a interim order as per the section 4 and 5. And if you want a permanent order, again you can pray. And then other orders that you rely on, such as the orders A to I, R to O, A to I of the Domestic Violence Act, you can ask all the relevant reliefs you are rely on through the affidavit. So don't forget, you don't need an affidavit. It's not must, but in certain situations, I followed that. In addition to the petition affidavit, sometimes I add a petition where the petition clearly describes the relief that we are seeking. So sometimes I face situations where other party took the objection. No, it is not the exact case, because the act says it has to be identical as per the schedule 2. But when I argue differently, through the written submissions, some of the judges or the most of the judges accept that or file a petition is no harm. It won't affect the case. But since the Act says only the affidavit, better be strict with the affidavit and seek all our prayers through the affidavit. So it has to be the lawyer. I prefer lawyer, but police also can do. If the police is doing it, there is no necessity for affirming affidavit. But if the lawyer is doing, you need an affirming affidavit. And then generally it's only the affidavit, but there's no harm of filing a petition and affidavit. Also, all the annexures. I think I can describe later annexures, but yeah, Kavin.
Now, when it comes to a young child, or a school student who's a schoolboy, maybe a teacher or a principal of that school, can they provide the affidavit instead of the child?
So
on behalf of the child?
Now the access guardian or parent of the aggrieved child, guardian or parent. Now, if the violence is coming from parents, in generally, I mean, for a child, in most of the situation, either father or mother or both, they unleash violence against the child. So then the guardian should be the teacher or a parent. And also, if that child is living in a protection environment or the protected environment or under protection, even that protection officer can file the case, or any other party identified or authorized by the National Child Protection Authority. Now, Ravinder, the difference between our Act and the Indian Act here, they have clearly identified a protection officers in the Domestic Violence Act, where we are not very specified, we are not precise on the protection officers. It covers a wider range of people, but it's good if we identified protection officers very specifically, then the protection officers can intervene. So again, in our Act also, the protection officer, the people whom authorized by the NCPA and teachers and principals can, but then you have to define on what grounds you are filing this case. So it's a bit of an additional work.
Child Probation Authority also has doesn't have a huge role to play in this kind of.
Exactly. The protection officers generally comes under National Child Protection Authority and even probation department, a probation officer. They all are, in my opinion, entitled with the facts that they found, they can file. Now, in those cases, there is no hard and fast rule that before you file this case, you must go to police. So if a probation officer or if an authorized person by the National Protection Authority, if they file by virtue of their office, they can file. And when they file, again, there is no necessity for affirming affidavit. Only the private plaint, only the plaint or the affidavit you have filed through a lawyer, you need an affirming affidavit. So please remember that it's a very clear, important factor when you file the domestic violence cases. Plus, the jurisdiction is magistrate court. The magistrate court of the aggrieved person, where the violence takes place, where the aggrieved person living permanently or temporarily, is the jurisdiction of the magistrate court to file this case.
Yes, coming to the practical aspect of that, since we are on this, now we are well aware that most of the times when it comes to children, we go to the juvenile courts. Is there a possibility to maintain two cases under domestic violence in the magistrate's court at the same time in the juvenile courts? Now, this is something sometimes clients also come and have asked me.
Yeah, Ravindra, I think our law sometimes misunderstood in that. So juvenile courts are mainly to solve the issues under Young Persons Act and few other acts. So Young Persons Act it describes when the judiciary can intervene or the magistrate can intervene. But here, I don't think if you file a domestic violence case for a child, you don't need to file another case in the juvenile courts on the same grounds. You may have filed a case in the area of if the both parents are neglected the child, then you can go to juvenile courts under Young Persons Act, I think section 34. In the other hand, this Domestic Violence Act application in the magistrate court does not prevent you to go to civil courts in relation to the custody. Still, you can go for, as per section 24(1) of the Judicate Act, to the family court, to the civil courts or district courts to seek a custody order, temporarily or permanent. So these are connected but clearly defined and distinct areas of law. So you are going for magistrate court on domestic violence, on violence only. And if the both parents neglected, then you can go to under Young Persons Act in the juvenile courts or even a magistrate court. And for custody of the same child, you can go to district courts. And now it's very interesting. Now, in certain situations, the magistrates issue interim orders or temporary protection order or interim protection order. The interim protection order, section 11, A to I, describes if the father is the relevant party, the father will be restraining to visit the child, go to the school of the child, talk to the child, so on. That doesn't mean that, I mean, maybe the mother has gone to court and obtained all these court orders. That doesn't mean that you will not be able to go to district court to take a custody order. No, it's totally different jurisdictions, totally different intentions. So don't take wrong that when you have a favorable order for you on child's protection from the violence, does not mean that you have the custody. To have the custody, Judicate Act 24(1) very clear that you have to go to family courts because the magistrate court has no say. I'm repeating it. Magistrate courts has no say on the custody of the children. It is purely a matter of district court or the family court. Magistrate court cannot do anything on the custody. They only can look at the protection or the protection from the violence, not the custody. So we sometimes mixed up this. Sometimes even the magistrates issues the child should go to temporarily to mother. No, it's wrong. I have gone to Court of Appeal several times on such things. It is only the district courts. So don't mix up this violence. Protection from the violence is a kind of a custody you can rely on.
Yes. So now the first thing, we make an application. Now, for the immediate application, we can get a protection order. What comes after that?
Yeah, Ryan, I think it's better I can explain about the interim protection order. The section 4 and 5 talks about the interim protection order. Now, again, I also would like to say that sometimes in the very early stage, I found when I go to magistrate courts, the subject clerk or the registrar, sir, other domestic violence gone dawsak nevi. In my opinion, that is totally wrong. The battering husband or beaten wife cannot stay for 3 days until the day that magistrate court take the domestic violence case. Every day of the magistrate court is a day for the domestic violence because it's a nature of the case is urgent. So remember, if you can file a case at least before 12 o'clock of the day, the magistrates are now taking the case on the same day, afternoon. Once you get the case number, you take the case. So when you go to the magistrate, you go with your client, then you can ask magistrate, Your Honor, I will submit I will make an application and I will make my submission I make an application to obtain certain reliefs. If your honor is approve or willing or want to hear my client is ready to give the basic to have a basic inquiry, because sometimes magistrates expect the aggrieved person to give evidence or at least to ask few questions. So it's better, I'm always saying it's better the aggrieved person speaks, or you ask few questions, not many, few questions. And if the magistrate also wants to ask, allow to ask few questions. And then with the supporting documents, what are the supporting documents? The supporting documents includes if you have beaten, if you are taken to hospital, and if your eyes are swollen, or if you have swollen arms or patches, contusions, everything, you can show by photographs, sometimes by of a medical report. Sometimes every person who got beaten will not go to doctor because they know that these are family disputes. So what you can have is a good photograph of your eye which is swollen, or your swollen lips, or your cheeks with slap marks, anything on scratching marks in your body, any beaten, any wound, anything you can take photograph. If you are reluctant to go to a doctor, but still if you want to proceed with your case, so bring some photographs, medical reports, and affirming affidavit, which is must, as I said before, and any other maybe previous police complaints about the previous incidents. So you can bring any of those things as annexures to your affidavit. And if you also can take something like X-ray reports of the previous incidents, still you can do that one. And if you can get a report from a doctor or psychiatric or counselor, values, especially for children, if the child are beaten by the husband or wife or parents, and if you have a good report by the child psychologist or a psychiatric, take those things, because it shows the picture. It gives an idea to the magistrate to decide what had happened really. So take as much as possible, provide as much as possible evidences to magistrate to help the magistrate to decide what sort of protection orders that the magistrate can offer or give or order. Because we can ask so many, but if the magistrate is not satisfied in every aspect of the prayer we are asked or we sought for, the magistrate might not give. Sometimes, I think you are asking, sometimes there is a relief under section 11 says that preventing entering to a joint business premises. Sometimes we are, without much thinking, we just put that one also. But actually that man and woman are not knowing any joint business. There is no joint business premises. But for the sake, we are just putting those, don't do those things. Sometimes magistrates don't like that they put too many things, irrelevant things. And also, some magistrates, they want you to describe the relief that you are seeking as per the section 11. So you have to say Vasasthan Atulima, and not to entering into the residence, and no stalking. Stalking is that passing and going after, and not to go to child's Montessori or school or preschool, not to come to your workplace, not to call you, not to disturb your helping people like your counselor, nor your doctor, your parents. So there are a lot of reliefs that you can sort. So those reliefs you better mention in the affidavit as it is in the act. So the magistrate also well aware. And when it comes to the prayer part of it, you can say, well, as per the section 11A, A1 or as per the section 11 B1, like that you can spell it out more precisely. But if you have given it in writing, what are those reliefs, so that will be easy for magistrate to. So when you ask some of those things as interim relief, and if the magistrate thinks that whatever after going through all the documents that submitted by you as annexures, and if it is relevant and if the magistrate satisfied, in most of the situation, magistrate will give you all the relief you sought under the interim protection, and then issue a notice to the other party. Now remember, I think I will take few minutes to take on this part, Ravindra. Now, these kind of cases are not punitive cases. In our law, we have two sections: punitive action, preventive action. So domestic violence cases are coming under preventive law, prevention law, preventive law. So the domestic violence is a prevention, part of the prevention laws, such as Section 81, Section 98, domestic violence, Section 66 of the Primary Court Act. So all are preventive. So remember, you have only, when it comes to the case, the petitioner or the aggrieved person, and the other party, once you file the case, the relevant person will become a respondent. So in the case, the other party will become respondent. Respondents won't get any summons, but they will get notice. The court will issue notice to the other party to come before the magistrate within 14 days and give your part of the story. So that is the first few steps of the case, and I can explain the rest in yeah.
Yes. Now, just a small reminder to all the viewers who are participating in this webinar, you can pose your questions. We'll be taking questions after around 6:30, because we are going up to 7 o'clock. We'll be taking your questions around 6:30 and onwards. You can post your questions in the Q&A box. So with that reminder, we just, you stopped at a very crucial point there, sir, because now, the moment we say the domestic violence cases, they come in the magistrate's court. And there is a misconception I have seen amongst clients mostly, and sometimes young lawyers also. Are these considered criminal cases? Now, you said that these are preventive cases, these are preventive actions. So that the moment you file a case, a petition and affidavit, the respondent gets a notice, not a summons. Now, the general view is when you are called to the magistrate's courts, people who are called respondents, we have a feeling that we may need to bring a surety. We may need to be given bail. So most of the time, sometimes the respondents who come to us as clients will ask, do we need sureties? Do we have to be escorted with maybe two people, friends or family? Is there a surety, a monetary one, or something like that? And at the same time, if a respondent is not there, will he be warranted? Will the police come and arrest the respondent? And in case of absence, or maybe absent-mindedly, or maybe deliberately, if a respondent does not appear at courts, will he be arrested and maybe remanded and produced to the magistrate? Because when it comes to criminal cases, these are the kinds of things that can happen. So the moment a case like this comes in the magistrate's court, we have these general misconceptions that this is also maybe having that criminal aspect. Maybe police may have a better role to play in case of a violence, in case of violating courts, maybe not being absent in court proceedings. Can you please explain to everyone who's listening and clarify this issue?
Yeah, Ravindra, I think I will add with one point and go ahead with that, your question. Now, the magistrate does not have a discretionary on this matter. right? In certain cases, we have a discretion, the magisterial discretion. But here, there is no discretion. If you have to submit a proper case as per the procedure, the magistrate has to issue whatever the order, whether it's a interim order or notice only. The magistrate can do two things. Magistrate can issue an interim order, or you can say notice only. Let the other party come and then I will decide whether I'm giving a. But if the situation is severe, I don't think magistrates will not issue interim order, because if the severe situation comes, but if the nature of the application is not that severe, then the magistrate will issue the notice only. So, Ravindra, I would say these are not punitive criminal cases. These are preventive kind of. So, preventive laws are always quasi-criminal. These are quasi-criminal. These are not completely criminal, right? So, there are no bail in Domestic Violence Act. I know a lot of situations in many courthouses, the bail involved. I think, in my opinion, it is wrong. No bail is necessary. That's number one. No cash or surety bail is necessary. No remanding. Now, what will happen? The police, when a severe commotion take place at home, a husband beaten the wife or the wife beaten husband, when they lodge the complaint into the police, what they do is they take the perpetrator or the relevant party or the one who beat the other party into the magistrate court, and they ask for remanding, which is totally wrong. You can't remand the victim or the perpetrator, or in the other words, agree person or the relevant party. Only you can give restraining orders not to do so. So if the domestic violence in a severe nature, if the first day itself, even ex parte, the magistrate can give as much as possible restraining orders as interim orders. So that means once you deliver it to the party, they can't do anything. And then arrest and detention or remanding is not permitted. So if a magistrate remanded someone, what I did, I can't accuse the magistrate. So I called the police and said the police have misused the law, abused the law. And I, as much as possible, I say everything against the police, because then magistrate also will understand there is no such provision in this act to remand. Remand comes later. If you disobey or violate a court order, then on the summary procedure, the court can take action. But before that, there is no punitive action. So everything is to prevent. Because the whole idea of the Sri Lankan law was to help the family to patch up. This is not a divorce law at all. This provides space and environment to family to patch up. So moment you give punitive orders, the husband or wife will say, you taken me to court, you arrested me, you remanded me, I will never patch up with you. But when you provide the space to say, okay, you better refraining from certain things. So it's not refraining, it's a prevention. So then it helps to family to patch up. It won't go towards divorce. But if you are such an egoist person, of course, it's a different story. So please remember, there is no general punitive actions available in this act, such as bail, no remanding, no summons, no sureties, nothing. No fines also. The court advise you refrain.
As you said, I think one of the reasons why it was very reluctant at first to bring up this kind of law was, as you said, like the moment you go, one spouse go against another to courts, it's very difficult at the end of the day to reconcile because of the ego most of the times.
Yeah.
And at the same time, sometimes family members will say, will make a huge say as, why did you go against your spouse to courts? Do you really have to do that? I remember before the enactment also, it was earlier, the moment there was some sort of harassment or abuse, to go to police or maybe the Women's and Children's Bureau. They try to settle. They try to settle and patch it up. But now with this enactment, the immediate thing is a protection order rather than you asking the spouse who's the victim to go back home and settle and patch up. You give a chance for them to have a protection, maintain certain distance, so that there will be no immediate bodily harm, which is a very proactive aspect of this legislation.
The proactive, yeah.
I believe that
Yeah, and
this is one. Yes.
Yeah, I think I want to add few things. Like when you come to the annexures, sometimes you can add videos also, narrations of the audio, and then also psychological reports. Sometimes school teachers report of the child, and also sometimes the affidavit of the neighbors also can be submit to the magistrate as a supporting document. And as you said, there are always immediate remedies. Immediate remedies is to prevent or giving a platform for you to patch up or some cool down the situation. In the other word, to cool down the situation, and also I would like to add a few points, because then we can go for a discussion on this subject. That the section 6 talks about the permanent protection order. Now, we know, and most of the, we heard the story. Some very, very prominent people, they have sometimes forgotten to extend the protection order. So if you forget to extend the protection order, the relevant party can reach you without any problem, because the protection order expired and there were some tragedies took place because you forget to extend the protection. So don't forget, after 12 months, it expires. So please go to magistrate court around 11.5 months and sort of extension of the protection order. And then, Ravinda, yeah, sorry.
With that, let me a very practical situation when it comes to that. Now, say for an instance, the violator or the person who is harassing the other spouse, maybe he or she is a habitual offender, and now immediately as the offense takes place at home, maybe for another offense, he or she may go to prison, maybe a sentence of let's say 8 or 9 months, or maybe 1 year. He's in prison. Now, the remaining spouse has already also taken a prevention order, the protection order, which is extended for 12 months. Now, you forget by the end of 11 months to extend that. And I have seen instances where the party was in prison after maybe like a pardon, or maybe like after spending the whole sentence, after 1 year, comes back home and has even murdered the spouse for the same reason.
Yes. Yes. Correct. That is the cautioning I make. But there were known incident of that. So please don't forget, if the other party is still violent, and if the violence not faded away, and if you still believe that violence is prevail, please don't forget to sort. The lawyers have to play that role. Please go for extension of the protection order. Ravindra, I would like to add few other points. Now, the magistrates also can refer you to counseling. Now, counseling or family counseling or psychological counseling does not mean that both the husband and wife goes to the same counselor at the same time. That is against the act. Because the section 8 talks about when the relevant party, in other words, the perpetrator, comes before the court without a pleader, without a lawyer. And sometimes the relevant party said, oh, I want to ask questions from the petitioner or the aggrieved person. The Act does not provide that. Act says you can't directly ask questions from the aggrieved person. You have to pose those questions to the magistrate, and then thereafter magistrate will ask from the aggrieved person, and the answer, of course, everybody in the court will hear. So why you are doing that? Not to intimidate by even a word, or staring or any action, even inside the court, to give a feeling to the aggrieved person, a feeling of intimidation. But if you send both parties to the counseling, marriage counseling or family counseling, or not marriage counseling, the family counseling, and if the family counselor who can be the best and experienced person but does not have any authority to give any orders, the aggrieved person may get intimidated and may succumb to the threats of the relevant party or the perpetrator. So even if the magistrate orders, you can argue it doesn't match with the intentions of the Act, because Section 8 talks very clearly. The magistrate has to play the middle person's role when it comes to direct questioning from the perpetrator to the victim. So please, you can request the magistrate not to send both parties at the same time to one family counselor, but you can send them on the separate instances, go and talk, but not to let them meet together. That's one area. Other one is the magistrates can give orders on social workers, doctors, parents to help these family to patch up, to do family counseling, to do social psychosocial counseling. That is provided. And also monitoring. Sometimes the police can issue, the magistrate can issue order to police, to social worker, to monitor the situation, whether things are in order. And also remember this, whatever the interim protection order or the permanent protection order has to go, as per the Act, has to go to the OIC of the jurisdiction of both relevant party and the aggrieved person. Example, if the aggrieved person living in Panadura, the OIC of Panadura will be served a copy of the interim order or the permanent order. If the relevant party living in Galkissa or Mount Lavinia, the Mount Lavinia OIC also will get the copy of the order, the interim order, the permanent order, to watch the situation. Because sometimes, if again the conflict aggravated, these two police stations aware about what happened. Most of the situation, these things are not happening. So what I do in the practical way, from the court itself, I will ask the Honorable Magistrate, Your Honor, please serve this protection order through the court sergeant. Every day, there is a court sergeant at the court. Through the court sergeant to the relevant police station, to the OIC, and recorded it. So when you record the court sergeant's name and everything, hand it over to the OIC, the court sergeant also take clear precautions. OIC mahattaya menna nadukaratuma dennama kiwwa. So he knows. Otherwise, when you send it by fiscal or by post, it will go into the drawer of the OIC. OIC also will forget, or some other people will forget. When the party go to police again, the police says, no, we don't know about this court case. But when it's recorded, the police cannot say so. And then also the issuing either interim order or the notices. In certain situations, Ravina, you asked that question. Sometimes the relevant party, or we can say the perpetrator, received the summons, but decided not to go to court. So what will happen? Once you receive the notices and decided not to go to court, that means you are agree with the interim order as well as you have to follow the permanent order. Because once you receive, if you are abstaining, the magistrate have powers to impose a permanent order for 12 months and continue with the interim order as well. You are asked to come before court in 2 weeks. That is the notice says. If you by your own decision, if you decided not to go, it is your own problem. The court will decide otherwise. So remember that. And then if you absconding taking summons, of course, that's a different story. Then what I do generally, I will ask magistrate, Your Honor, please serve this notice to the police. So I ask generally by registered post, by FIS call, and by through the police. So it happens. So when you get the notice, generally police can trace a person when you get the notice. So then that party knows, okay, there is a case. If you of course, if you decided not to go, there will be order against you. If you violate, you will be penalized. That's a law. So you cannot be absconding from the court for a longer period. And even sometimes the court has powers to paste it. Paste the restraining order or the summons or the interim order in the general habitual place of yours. The door is not like, it's like the alternative way of issuing summons in the civil matters. So that provision also there. So generally the perpetrators will not be able to abscond the court for a long time, maybe first day, second day. And also I have to say, sometimes in certain cases, some of us try to get the undue advances of this act also. Sometimes we are trying to use this act to get the property benefits. Because if wife is living in the property, if the wife wants to get rid of the husband, and if you take the restraining order against the husband and interim order against the husband won't be able to come home thereafter. So then you can enjoy the property. So that is not the idea. And then in such situations, husband can go to court and say, no, I have not done any violence. This is a totally false story. And there is nothing proved before your Honor's court. So therefore, remove this restraining order because I also have nowhere to stay. I also will get a room in that house. So in such situations, magistrates consider, but with a strict order, say you can go, but not to disturb.
Yes. So now there you mentioned a very crucial thing about using the act, using this legislation, using the preventive order in a very beneficiary manner by a spouse. Now, in that kind of a situation, now I have come across situations like this. Now, one party takes a restraining order. Maybe the wife takes a restraining order against the husband. Now, anyway, in such a situation, unless maybe there are children, sometimes the husbands will not come to the house because it's very difficult in such a situation to come and stay, live together under the same roof sometimes. And at the same time, maybe the restraining order is such that you cannot actually enter into that house. Maybe the house is small, maybe the property is small. So eventually, the other party will be away from the domicile, from the matrimonial home. Can this be a ground? Usually, when it comes to divorces, we have this ground where it is maliciously, if a party deserts the other party, that is a ground for divorce. Can this indirectly be taken as a ground for divorce? Because I have seen where these kinds of acts, in a very crafty manner, certain spouses have taken as grounds for divorce, saying after this period of time, my husband or my wife did not come home. Or maybe like they are staying away from home for a long period of time. So is this have you ever come across situations like this? And if at all, what do you think can be done?
Now that's a very, very pertinent question, but I think very short. You can use the interim order or a permanent protection order to say that my husband is a violent person with the evidence and the findings inquiry report. But you can't use it for malicious decision or constructive malicious decision. That is
Yes.
wrong. People are using, yes, but you can counter it without any problem. This is not a tool to get the custody, to get the maintenance, to get the divorce. This is a temporary, remember, it's a temporary measure to allow the families, to allow the domicile people to patch up. It should not go to an end of separation. The idea of this is not the separation. But if husband or wife unleash violence against the other spouse, of course, you can take it as evidence, but not as a reason or ground for divorce, or ground for custody, or ground for maintenance. So please remember that is not permitted, or you can easily object. You can easily go for file objection to take up that as a ground. And also, yeah.
At the same time, now we spoke about the aggrieved party, so the person who goes to the courts at the first instance. Now, say for an instance, we are representing the respondent. What are the remedies available for a respondent? Do you think that they have to counteract, or is there a possibility to go for an inquiry? What if the respondent is an innocent party?
Ravindra, now the surveys talks, recent surveys talks, 2% of women have gone through domestic violence of the country. I mean, this is one of the survey. And also that certain areas, it goes up to 17%, certain part of the country. And every married person, it sometimes 12 to 13% they undergo domestic violence. But in certain areas, there is more. That doesn't mean in this modern world, it's only the husband will get violence or receive violence, or the wife will receive that. Both parties are receiving violence. So whether you are appearing for the husband or wife, to the petitioner or the respondent, you have a story to tell. If you are unnecessarily accused, then you can go. Sometimes if a spouse is going through a mental agony or mental condition and look at everything in a very negative way, then they sometimes go to courts with unfound information. But they can create a picture that I'm in a serious situation. So then the other spouse, with a husband or wife, can file enough and enough evidence, medical reports, psychiatric reports, and also ask the court to call for psychiatric reports. The court will permit, call for psychiatric report of the other party to see whether the other party comes to court with a sound mind. So that provision is available. So it doesn't mean that only when you name as a respondent, your life is finished. No, you can fight back. You can fight back. The fight back provisions are there. So yes, in most of the situation, in a patriarchal world, the wife will be the victim in most of the situations. But in the modern world, the number of male victims is also increasing. So that is why the Sri Lankan law talks about the domestic violence instead of the violence against women. So, but don't forget the fact that the majority of the people who comes to courts as an aggrieved party are women. Still, the Sri Lankan society is in that notion.
Yes. So we have come to a very interesting point there when it comes to the fact that it's a husband or a wife, male or female, anybody can be a victim. Now, when we talk about the act, when we look at it, we see the framework of the violence that takes place in a household, in a domicile. Now, I have come across clients who are cohabiting, but not married, legally not married. Husband and wife who are cohabiting, but not legally husband and wife, but maybe you can even call it as habit and repute. They are called husband and wife. So at the same time, they may be having children also. in such a situation, are they also covered under the Act? And at the same time, the recent trend I have seen, sometimes there are cohabiting same-sex parties who are also considered spouses. Are they also protected? Because even if you are the same sex, if you are in a same sex relationship, sometimes the parties, one party can be violent and can be harassing the other in a similar manner as if it is the normal husband and wife situation in a legal marriage. So, in these two different situations, sir, is the Act covering these kinds of situations? One is where I said two parties cohabiting, male, female, but not legally married, but is still a family with children. And the other is in a same sex cohabitation. Does the Act cover such couples?
Yes, Ravindra, our act's very clear. It's spouses, both husband and wife, the previous spouses, man or woman, and your cohabitating partner. They are not saying any cohabitating any other word. They use partner, sahakaru or sahakari. So all
Yes.
are covered with having children or not having children, right? The cohabitating partner is also subject to this law. And also, I would like to add few other points on that you asked about the same-sex partners. Now, the Supreme Court, the special determination on the decriminalization of the Section 265 has clearly mentioned its determination to the Parliament that it is decriminalization is not inconsistent with the Constitution. But still, 265 is our law. The day that Parliament decriminalize, then it will also applicable to this law. The day the Parliament says this, the same sex or not same sex, same sex sexual relationship is not a criminal offense, then they also will cover because they are living in a cohabitated background.
But not right
There
now.
are instances, not right now. There are cases, but you can't proceed because though it's not public, but you can't take the cover of the law at this moment since it's a criminal at the moment in the law. So I do magistrates now. I can when you say protection orders and the interim orders, they can go to ask for social service or counselors protection, and then you can ask a separate shelter. The court can order a separate shelter to the aggrieved person. Further, under the Victims and Victims Protection Act, I was told very clearly there are shelters, at least one shelter, run by the Victims and Victims Protection on those who are gone through the domestic violence. And there are some NGOs who are running safe houses and shelters for those who are victimized by the domestic violence. So you can get a magisterial order to go for such place if your violence is severe nature. And also, if magistrate thinks that the relevant party or the perpetrator have arms in that household, the magistrate can issue order to police to unarm that party, take over all the knives or guns or bullets or the bombs or whatever it is. And then also, if the family is getting income from an estate or from paddy fields, that if the wife especially wants that for their survival of her and the children, the court can order to allow reap the harvest. And also, and sometimes the magistrate can order to husband to continue whatever the payments he made to the wife and children for their survival. And also, if the part of the house is given on rent, to obtain the rent to the survival of the family. So this covers a wide range of orders plus the police protection. Even the police protection is available under this act. So it is not a simple thing. And then we can go to the other section, section 13, which talks about the settlement or the mutually agreed settlement. But the court is very particular. Court has to see or looking into whether this is the protection comes under duress. There cannot be duress, under duress on that you agree. No force. There should be no force to if you agree on a settlement. And
How is that
this can
monitored? How is that monitored? That there is no
yeah,
duress.
yeah, so the court have to have inquiry. Sometimes the court will do an inquiry. Court will ask questions from the aggrieved person. Now you want to settle, but are you on duress? Or you can ask maybe a family counsel. Court can refer the aggrieved person to a family counselor and ask take a note of it or take a report of that person and submit to court and say no, this party is doing it's because it must be 100% voluntary settlement, not a settlement by force. And then the section 14 says the interim orders or permanent orders can be altered or modified. And also, yeah, that is generally on the section. And section 23 covers about the interpretation part. So it says what is the Domestic Violence Act. Now, very importantly, sometimes you don't have any annexures or any supporting documents or any evidence to say that you are under violence. But the Act says even verbal violence or verbal allegations, verbal mental harassment is part of the domestic violence. If a woman is being called as a whore or a prostitute, that itself is enough. If you can record it and give the narration and the recording to the magistrate, that itself enough to ask for a protection order. May not be everything under the section 11. Section 11 talks a lot, but some areas, at least to refrain. So this act, I mean, same with the man. I mean, if the woman accused a man in a very bad way of something sexual kind of words, that can go against the woman as well. So the mental aspect of it is highly part of the act. And also Ravindra, I think now we have discussed about the LGBTQ community or the same-sex community and the DV. It cannot be done at the moment. And then if somebody violate the order by the magistrate, that is either interim order or permanent protection order, then there should be a summary procedure to decide by the magistrate, and magistrate can impose fines and imprisonments. And I think most of the other things we have talked about. And also in Indian Act, the Indian Act provides inquiry in camera. In certain Sri Lankan courts also follow that. So if you think that your client, who is the wife or a child who needs inquiry by camera, you can request for it, because our courts now equipped with all the necessary facilities, even sometimes taking evidence from abroad. And then, yeah.
Since now you mentioned the Indian Act, so as you mentioned earlier also, we are most of the times we are maybe in par, or sometimes we are following the Indian enactments and even the penal code, the criminal law of Sri Lanka. So in 1995, I think we lost that opportunity. Earlier, there was this aspect where we could, where a husband could be convicted for raping the wife. We now no longer has that marital rape part. We never really in that way.
There was a proposal.
There was a proposal, but I think in 1995 we did not even follow afterwards the whole aspect of the husband raping the wife in the domicile while the marriage still is on. So can the Domestic Violence Act be used as a tool, not to convict, but at least to prevent situations like marital rape?
Yes, can. Now, if wife can prove the sexual violence also violence. It's a mental violence, it's a mental harassment, and the physical violence. So she can now the best provision. Now again, it's preventive, not punitive. What you can do is not to go for a punitive action like put the man into prison, but
Yes.
prevent the man coming to your bed. That simply. That provision is there. And then also, I'll take the same point, the section 16. In general criminal law, the husband is not a witness against the wife. But in
Yes.
this act, it says the spouse shall be a witness against spouse in domestic violence cases. So that provision is there. So you can take certain allegations against your husband or wife, or rather, in better words, spouse. Yeah. Is there anything, Ravindra, or we can go for questions?
Yes. I believe, we have been covering most of the aspects that we were planning to discuss today. Now, since you mentioned this part, section 363 is on sexual harassment. Now, when that is there, can the domestic violence act also be a part? And is there a possibility that there can be two cases maintained, one in under the Domestic Violence Act, at the same time under the section 393?
345 or 393?
Yeah, harassment, sexual.
Now, sexual harassment 345 is you can maintain, but again, that is an offense.
Yeah, that's
a
right.
punitive, that's a punitive action. But you can maintain a preventive action on the same ground as, because what you are asking is prevent a person. So there is no punitive action. It is not offense. So offense is something that you have already committed.
Yes.
So here, of course, something that you have committed or to be committed, or there's a threshold, or there's a possibility of commit. So therefore, I think, in my opinion, I'm not very clear about that, but in my opinion, both can be maintained. And then also, Ravindra, this interim orders in the first instance, the ex parte interim orders, you have to extend it every 14 days whenever the court case, because if there is order. And then other points which I think I want to talk about is, I've already talked. And I think we better go for questions if you have anything.
Yes, we have one question. On which party does the burden of proof lies when it comes to allegations? Yeah, this is an anonymous.
It is a respondent. It's a respondent have to show cause that why there should not be it's almost like a section 81. Why you should not be why a permanent protection order is not been imposed against you. You have to give show cause. So the husband, the respondent, has to give all evidences and all defense why there should not be a permanent order against you. So it's a burden proof with the respondent.
Is now until we get other questions with regard to that. Now I had one instance where the party who went to courts, the wife, she's a schizophrenic. So most of the allegations that she has put in her petition were all situations that were in her own mind, and the husband was not even aware of it. And so in such an instance, can the husband or can the party who's the respondent go for a medical inquiry or like ask the magistrate's court to magistrate to order for the victim to be put into a medical inquiry to
Yeah,
see
Ramja,
whether
I think I've said earlier also, the magistrate court can refer the both parties to a counselor, psychologist, psychiatric, and call for medical reports. So when both husband and wife went to the medical counselor, social worker, family counseling, and psychiatric, they will bring reports to the court to say that I mean there's a mental condition. So in such situation, this is very obvious. This kind of thing there can be some hypothetical allegations, yeah, which is not in practical world against the husband or wife. So if the husband and wife, the respondent thinks that this is totally, hypothetical, then they can call. This is not never happened. The other party is my husband or wife is a patient, schizophrenia patient. So call for medical report. That's possible. That's possible.
and also another interesting point there is a case also going on right now where when it comes to
Ravindra, before you go for that, something which I got forget. Now,
yes,
when this kind of cases going on, media cannot report this. There
exactly.
was a case, and the court, reprimand or even fine the media, because this is not a matter to media to give wide publicity. This is a very private domestic matter. Those private domestic matters cannot be reported by the gossip sites, by the YouTube or Facebook or print media, visual media, nothing. If you do it, you are liable for punishment and fine both. So please don't, as a lawyers, don't encourage media to take up these cases, because sometimes even your client might do it to get undue publicity against your spouse. Go to media. That is impossible. That is prohibited. Sorry.
This is exactly where I wanted to pinpoint. So this went to media, unfortunately, and this has something to do with one party calling the other party's sexual behaviors weird and harassing and abusive. So will it also be covered by the domestic violence?
Yes, if you go to media, if you go to social media or any other media, it's prohibited. You can't talk anything about the entire case. Yes, there is not a single word you can talk about this particular domestic violence case on media, irrespective of social media or mainstream media. And there are decided cases on that.
Right. So,
any other question?
I think there are no questions in the question box. So we have covered most of the practical aspects. At the same time, now since we are there, as you said, that this is a preventive legislation rather than a punitive or something where party is punished. Now, when it comes to the settlement, once parties settle, now this is something sometimes even clients ask. Now, you had a preventing order, the protection order, so that is over. Parties have settled,
and then it will be dissolved.
Yes, but if it repeats at the latter part,
you can come to courts again. You will, though you have settled and the order dissolved, does not mean that you will not be able to. Violence can erupt any moment. It's like a war between certain countries in the world. All the time the war erupts. First year you settle, and then second year it erupts again. So this is kind of situation. So it may not repeat again and again. Like, okay, once you settle and then erupts and then you come to courts, settle. No. Once you erupts, You come to court, settle, and it erupts again, yeah, then you can give an order, but then you can't go and settle again. Then the court will ask, okay, it happens, we settle, you came again, you want to go again for? No, I don't think court will take into the consideration the previous incidents also. So I don't think it will be repeated like that. Same thing will repeat. So dissolve is a possibility. Dissolve is a possibility, and court will ask when the inquiry also. Now you have the both parties agree to settle, and you both parties experience it again. Why are you going to settle? Let the order will be remain. Then the protection for the both parties.
Yes. So one other question is now in the question posed by someone in the webinar. A problem is that if the court goes to hear the case, sometimes the trial goes on for more time than the maximum duration of the protection order. That is, whilst the interim order is active, which is unfair.
Now, I think that question is in a way a bit of a questionable, because now when there is a protection order, the protection order until the court issued the permanent order as per the section
Yes.
6. So all the reliefs you sought in the protection order will remain or prevail until the permanent order is imposed or the case dissolved or dismissed. It can be the other end also. No? Either court will upheld the aggrieved person's position and impose a permanent order, or the court can say we have not found any reliable or evidence against the relevant party. So therefore, we dismiss the case. If the case dismissed, all the previously given interim orders will also come to a standstill. But until such time, the interim order will prevail. So nothing can be done. Even if the case goes for 4 years, I mean, generally the domestic violence cases has to have an expedite interest, or expedite, the court has to expedite the proceedings. But in case if prolonged or proceeded for a longer period, that particular interim protection order still prevails. So you don't need a losing end. But at the end, even in the 3rd year or 4th year, the only 2 things can happen: either impose of a permanent order or dismiss. If the court found no reason to impose a permanent order, court will dismiss it. If the court found after evidence taking inquiry, then there's a very clear case for imposing a permanent order, court will impose for 1 year. And then the case, only you get the permanent order at the end of the case, not in between. In between, you get only interim order. As per the section, the relief that you can sort in the section 11, as per the section 4 and 5 of the Act. Section 6 talks about the permanent order only valid for 12 months. So that is why I said after you got the permanent order, then end of the permanent order, that is 11.5 months time, you better go to court and ask for further extension for another 1 year. If the things are not getting better, you can ask for further. So every 1 year, if the things are in the same old nature, you have to go to courts.
Right. So before we end, I think apart from the question Q&A box, I'm just getting 2 questions. I think they are very much the same onto my WhatsApp, right, on live. One is from one of my juniors, and it's almost the same question. That is, now, if a party goes to courts on domestic violence, based on maybe a false accusation, can the respondent counterclaim, stating that the entire case was a futile one, and that he or she had to come to courts in vain, and had to pay for the lawyers and waste the time. So as in a similar criminal case. So can a party make a counterclaim against the spouse?
No, this is the nature of the preventive orders or preventive law is like as such. The preventive laws does not talk about the compensation for malicious persecution. So maybe you have to do in the first instance, when you were asked to come to courts on 14 days, you better go to courts and submit your case with all the evidence you have, saying this is a false case. This is a case misconceived in law and bad in law and hypothetical. So therefore, dismiss in limine in the first instance because there is no case. But to do that, you have to submit your case very strongly to show that there is no such case. But if the magistrate still found there are some loopholes, magistrate may order to go for an inquiry, but in such situations, you can ask for quick inquiry or you can expedite inquiry. So then you can end the case quickly. But we have to remember that in the courts, there are two parties. The court has to listen to the both parties. That side has lawyers, so both side will try to, if some party wants to drag the case, they can do that one. All things are there. But remember, dragging of a case is also amount to your active involvement of your case. I mean, if you are not actively involved in your case, then the other party will be able to drag it. But if you are actively involved in the case without failing, you come to courts and involved and doing your submissions and objections and written submission on time, the cases won't drag. So it is sometimes our own contribution helps the cases to be dragged. So I think you can ask for compensation for malicious persecution, but that other party may not come to court again on the same ground, because then you can say she or he has come to court previously and your honor's court had dismissed. So this is a similar hypothetical case there without any basis. I think I prefer that participants to ask questions. It looks like they are feeling very boring of our story.
I think that's all in the Q&A box. Yes.
They can ask questions by, they can use the audio mode and they can ask questions if you have any clarifications you need.
Yes, we still can take questions.
Yeah, and also one thing, unfortunately, still these domestic violence cases has not reached the Supreme Court and Court of Appeal level to have a judicial precedent. I think we have very, very limited cases, maybe one or two in the Supreme Court and Court of Appeal level for us to take the judicial precedent. So I think this, and also I think the government is on the process of revisiting the act and do the amendments, the modernization of this act, because after 20 years, I think they are doing it. They are taking more proposals. So if you all like, you can do. All right. So they can only type. Yeah. If you don't have.
Yes. So maybe like in the meantime, just taking the advantage of the few minutes left. What about the in-laws? What about the son-in-law or the daughter-in-law? Are they covered? Because Act specifically does not mention that.
Yeah, Ravinder, I think thank you very much for asking that question. And that is one of my criticism on the Act. The daughter-in-law and the son-in-law is not covered by this Act. The father-in-law and mother-in-law are covered. It's specifically covered. But not the daughter-in-law and the son-in-law. Banai leli cover kala nahi. Because most of the domestic violences in Sri Lanka or even India
Yes.
is erupted through the son-in-law or the daughter-in-law. But they are exempted. They are not covered by the Act. I think I hope that the legal draft department or the Minister of Justice who are revisiting the Act will take into consideration this lacuna in this Act and will include the daughter-in-law and the son-in-law also into the relevant party list of the relevant party, which they have not covered in the original Act.
Just because even when the cousins are also being covered, this is a very crucial point, which I think
Yeah, I mean,
has,
we have covered a lot, but for some reason, we have missed these two aspects of son-in-law and daughter-in-law.
exactly.
And only thing I have not given all details of the section 11, because section 11 is very clear. What you can
Yes.
sort as a relief in the interim order and the permanent order. So it's sort of a wide range of relief you can sort as per the section 11. And if I read it, you can stop the relevant party enter into your house, office, or school of the child, and to a place that you are temporarily living, and then a place that you are generally habitual, where or part of it, and a house that you are cohabitated, and if a parent is the relevant party, to try to connect with the child, and also as I said earlier, that if somebody is enjoying a property, especially something like coconut estate or paddy field, which they give income, you can get orders to refraining them entering to that, and also to threat or harming the people who are supporting the aggrieved person, or the doctor, social worker who are supporting the aggrieved party. I mean, not to harm them, and the stalking, that is pasupasayama, and then also and then anything that that can be harmful for the aggrieved person, not to do anything that harmful for the health, for the good well-being and protection of the aggrieved person. The court can give orders, and also you can't sell the properties. You can't sell the properties. Now imagine sometimes people do that one. You are living in a house and you chased away the wife, mainly husbands, chased away sometimes wives also doing, chased away the husband out of the wife out of the house and sell the property. And the wife has nowhere to go, because that's the marital house you have lived. So either party, both husband and wife, cannot put the other spouse out of the house and sell it. You can get a restraining order not to do so. And then also the act permits to get living expenses to the aggrieved person from the relevant party, not the maintenance, but the living expenses. And as I said, we can ask a relief from the Victims and Witness Protection Commission, and also safe houses from the NGOs. There are a lot of provisions are available for those.
Yes. Now, with the limited time we have, if there are no questions, at the same time, I think what I have seen in the practical aspect is, one thing, the victims are very reluctant to come up with their stories. So as lawyers, what do you think, what is the message you can give to all the listeners who are the participants, and all the lawyers who are involved in cases like this, about the listening part, the aid, assistance?
I think lawyers has to give a lot of legal counseling for this kind of people. You have to make sure that the client that comes to you by way of a domestic violence will get proper advice, and to build the confidence of the judicial review and the judicial orders and the protection, and also building good rapport with the police, and said, okay, in case of emergency, that police will support us. And with all these things, you have to take the party into courts with a lot of confidence build, because otherwise what will happen, if you don't do that one, the clients will, if the client has to come and waste their time in the court, they think that this is not going to work for me. I will suffer under the hands of my spouse, whoever it is. It's much better than to waste my time in the courts. So don't ever give that kind of a negative feeling for a client. Always to show them, okay, judiciary is in your side, if you have a genuine case. And the judiciary will listen to you and will give whatever necessary orders if you have a genuine case and if you have satisfied the court with all your evidences and supporting documents. So that confidence you have to build. You have to talk to the clients. You have to give little more time than the other cases, because they are coming after violence. They are coming after mental harassment. Their mental status are not same as some other clients. So you need a lot of attention. And also you better have some contacts with the safe houses, the NGOs who are supporting this kind of organization, psychosocial counselors, family counselors, police, in relation to get protection. I think we have
Yes,
covered
so-
everything, Ravinder.
Yes, I think we have covered everything. So the members and the participants who have been with us for 1.5 hours, I think I believe that both of us covered everything, and also the practical aspects of this act. Thank you very much, sir. And for whoever is there, if you are a victim, I think the good first step you may take is to visit your closest magistrate court and get legal aid if you do not have the financial ability to meet a good lawyer. So there is always a legal aid office, and there are enough and more available officers who will be able to help as well, because I have seen in many magistrates courts, many court complexes, the legal aid office, it has been doing a very active role. And most of these victims who are coming to courts sometimes are not in a position where they can pay, where they are not financially in a very good juncture. So I think if there are any, yes, anyone
Yeah,
who's
I
listening.
think, Ravinder, I think we must thankful for the the Legal Aid Commission of the huge work they do in relation to the minimize or mitigate the domestic violence. Unless otherwise not for them, I mean, that will be a much larger issue in the society. So they have been able to provide a lot of legal aid to those who are in the lower strata of the society, who don't have any means to go and retain a lawyer. So I advise always, if you got a client, if you cannot handle, please send to Legal Aid Commission, and then they will do a better job. Thank you.
Yes, so thank you very much, sir, and thank you, Isuri. I think we can wrap up the session.
Thank you. This brings us to the end of the 18th webinar of the series on Basics of Law titled Domestic Violence Act. I thank our esteemed panelist, Mr. Lakshan Dias, Attorney at Law, and our moderator, Ms. Ravindra Sumatipala, Attorney at Law, for the fruitful and educational discussion that has spanned more than 1.5 hours, actually, and for dedicating your time to be here with us as well. And I thank the BSL Webinars and Legal Symposiums Committee for organizing this webinar, and I also thank all our participants who have joined in with us today. I thank you once again, and I hope you all have a very good night.